Nice to meet you. right. All right. I want to welcome everybody to Criminal Justice Subcommittee. I'm not Chairman Doggett. He is running a little bit late, but we're going to go ahead and get started. If we could, members, let's go ahead and get signed in. Yeah. Members, let's go ahead and get signed in. And Madam Clerk, you open that board up for roll, please. All right, looks good. All right, Chairman Doggett should be here momentarily, maybe 10 minutes or so. Members, any personal orders before we get started? I'm sorry, what? Leader Lambert, you recognize.
Thank you, Mr. Chairman. I noticed that a few of you, specifically a few of you in the back, remembered that it was UT Day on the Hill. So as a proud alumnus of the University of Tennessee, Knoxville, go Vols.
There we go. Members, anyone else? And I appreciate you not reminding me that I forgot my orange, which I will have that on as soon as I get back to my office. So members, anyone else before we get started? All right. Looks like we have a calendar. Item 1, House Bill 1704 by Leader Lambert. You got a motion and a second. You're probably recognized, sir.
Thank you, Mr. Chairman. And then I believe there's an amendment coded 13082.
Members have a motion and a second. All those in favor of adopting amendment coded 13082, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're recognized.
Thank you, Mr. Chairman. The bill is a very simple bill that simply creates a misdemeanor for illegal immigrants that are present in the state of Tennessee that have received a final deportation order. It also has trigger language in this that if at any point the U.S. Supreme Court were to revisit some of the current precedent that is out there, specifically from Arizona v. United States, a 2012 case, that would allow us to expand that a misdemeanor to all illegal immigrants. And again, this would only apply to illegal immigrants. This would in no way, shape, form, or fashion affect anyone who is here legally. But if you are here illegally, this would literally make it illegal to be illegal in the state of Tennessee. Thank you, Mr. Chairman. I stand ready for questions.
Very good. First, let's have Representative Powell. You're recognized, sir.
Thank you, Mr. Chairman. As we know, immigration enforcement is a federal responsibility. You look at, I know you referenced Arizona versus United States, but that clearly limits states' ability to create parallel immigration enforcement. The bill appears to condition its effectiveness on a hypothetical future change in federal law. My question for you is an immigration enforcement constitutionally assigned to the federal government, and how does this bill avoid preemption concerns?
Thank you, Mr. Chairman, and welcome back. We missed you. So the safety of the people in this state are our responsibility. We create criminal laws in this committee every single year that improve safety in the great state of Tennessee. 41 people were murdered last year by illegal immigrants in this state. There's nothing that I could imagine that would be more important than reducing the number of murders, rapes, and robberies that occur in this state, and specifically doing so by deporting every single illegal immigrant, specifically those that have committed crimes, but particularly when there is a final deportation order that has been made, and it has been crystal clear that that person has gone through the entire federal system and has been told, no, you may not legally immigrate. You must go back to your home country. If that person remains here, this would create a misdemeanor. And my hope, instead of 41 people being killed by illegal immigrants, that number would be reduced to 0.
Follow up. Sure. And I guess I didn't hear an answer to my question, but I'm curious too how our state law enforcement would verify federal removal status. Would they have access to federal immigration databases? Would this potentially create a wrongful detention risk? And what training, because this bill would and data access, would state and local law enforcement require to enforce this accurately and safely?
Thank you. And yes, the exact same processes that they go through right now. This would be like any other criminal case. They would have to bring this case. Obviously, everyone is innocent until proven guilty. Just because a case begins does not mean it ends in that particular scenario in the same way that it started. And so just because a person is arrested, that requires probable cause. So law enforcement would have to have probable cause that this person is here illegally before they could arrest that person or charge that person, and then would have to prove that case beyond a reasonable doubt. Now, I will say that for the vast majority of these folks, after they are charged with this offense, obviously that's going to get the federal government's attention pretty quickly as far as deportation proceedings, because these are folks that are clearly illegal. There's not even a question as to their status. And so the deportation proceedings can proceed as that case is moving through the system as well.
Yes, sir.
I guess, have you considered the potential litigation costs or correctional impacts the bill might burden the state with?
Yes, sir. The fiscal note is not significant.
Representative Powell.
Yeah, I find that hard to believe. I guess I'm also concerned the bill creates a parallel immigration enforcement structure that could expose Tennessee to litigation, and while we're simply duplicating federal law. If you could address that.
Yes, sir. And again, we're not duplicating anything. This is literally creating a misdemeanor offense here in the state of Tennessee for someone to be illegally to enter or remain in the state of Tennessee. So this is not creating anything parallel to the federal government. This is literally a new offense that would be a state level crime of an A misdemeanor.
Okay. I guess, my other major concern here is I just don't think it's good, sound legislative practice to create a criminal offense that only becomes active if federal jurisprudence changes. I think we're going down a extremely slippery slope here to start passing legislation based on hypotheticals of what could happen. And maybe this is an attempt to try to take this all the way up to the high court. But, if we're doing those types of things, I find it to be irresponsible as legislators. And I myself don't always agree with Supreme Court cases and decisions, but I respect them and think it's in our best interest to follow the laws of the land. Could you speak to that?
Leader Lambert.
Yes, sir. You're referencing section 2 in this, and there is trigger language in section 2 that would be reliant upon a federal court case being overturned. Section 1 goes into effect pretty close to after passage. So it would be July 1st of this year. So if this bill were to pass, section 1 that deals with a final removal order would go into effect on July 1st of this year. Section 2 is the one you're talking about, is predicated upon a court case being overturned.
Representative Powell.
Yeah, so still speaks to my concerns. I guess in closing, I'm also just back to the same point as I'm concerned that we already have, and we should be looking at federal government's the one who enforces immigration law. This would expose us to litigation and duplicates federal law. Additionally, there are people who have been in this country for a long time that might have had a removal order put against them when they were very young, and there's no awareness of this, and now they could be exposed to this criminally under the state. But I think this sends us down a very dangerous path, and I'm hopeful my colleagues will vote to oppose the bill. Thank you.
Leader Lambert.
Just one quick thing. I mean, this bill only deals with adults. There are no children that are involved in this whatsoever. Even if they have a final deportation order, it is only for those that are 18 and up.
Representative Salinas, I know you've got a question. Do you want to do it now, or would you wait till after we got some people to testify? I just wanted to check.
So since we're probably going to go out of session to hear them, I have questions for legal as well. So that was kind of what I was going to bring up.
Do you care to hold those questions?
I
Okay,
can.
very good. Members, we'll go out of session. We'll hear from Steve Puckett and Alan King, if they're in the room. If you will, come forward and have a seat there at the table. Identify yourself for the record. Each of you will have 3 minutes for comments, and then we will open it up to the committee for questions. Whichever wants to go first.
You can go.
Rock, paper,
Sure.
scissors.
Do I need to press this?
No, sir, you're good.
All right, good morning. Thank you, Chairman and members of this committee. My name is Alan King. I am the current legal director at the Tennessee Immigrant and Refugee Rights Coalition. I'm here to talk today as an immigration attorney about how this bill grossly oversimplifies the federal deportation process and how, if enacted, it would create a logistical nightmare for local law enforcement offices across Tennessee. So the crux of the bill is that it presents a final order of deportation as a simple, easy to apply metric, but in reality, it's not. So the phrase final order in itself is a bit of a misnomer. So an individual can receive a final order and exhaust all appeals options and have had a final order on the books for 5, 10, 20 years. And it is still a possibility for an immigration judge to reopen and dismiss that case under the right circumstances. And so knowing whether or not that is an option for someone requires careful legal analysis by a seasoned immigration attorney. And without undergoing that analysis, local law enforcement could find themselves in a position where they've invested dozens of man hours on one investigation only for it to fall apart because that case got reopened and dismissed. To place this burden on local law enforcement is tantamount to requiring them to all have an immigration attorney on standby. And I think we have enough attorneys in this room to understand that would be an incredibly expensive undertaking. The other issue is that this bill jeopardizes the trust that local law enforcement agencies have sought to foster in immigrant communities. So there is an unfortunate reality that many criminals go after immigrant families with the understanding that they may be more afraid to come forward to local law enforcement. In my career, I've worked with a lot of police officers and district attorneys who've shared this sentiment and shared with me that it's incredibly important for their work to build this trust in communities so that when crimes happen, people feel safe to come forward and testify. Without those victim witnesses, investigations get harder, prosecutions don't happen, and everyone is less safe for it. To conclude, this bill harms immigrants and local law enforcement equally. For these reasons, I strongly encourage the committee to nix this bill, and I'm happy to take any questions. Thank you for your time.
Thank you for that. You'll have, identify yourself for the record. You'll have
All right.
3 minutes. You ready to go?
All right. My name is Stephen Puckett. I'm speaking I'm a citizen of Tennessee. I'm from Hendersonville, Tennessee, and I'm speaking for myself only, but there are probably other folks that may agree with what I'm about to say. I am speaking in opposition to this pro-trafficking and pro-racketeering piece of legislation, and you can check your hearing on that. That's what I said, pro-trafficking and pro-racketeering, because of a racketeering practice referred to as an intent trap. It is, there are various different versions, and as I've mentioned previously to this General Assembly, the primary driver of illegal immigration in our nation is importation by smugglers, by traffickers, and even by companies using deceptive visas and other aspects that will actually make this an enticement to them. The companies that are at the beating heart of this industry, they have actually created through horizontal shareholding and shell contracting and things like that, they have created enough legal separation from themselves that really the only way to effectively hit that and take out the beating heart of this machine is a market-wide tax on on the entire corporate system and their profits, and take the profit out of it. That's the only way to do it. And I know you guys don't like to announce as your legislative packages those type of taxes. So if you can give me the bill number for that, I would appreciate it, because you guys have said you're so eager to take this out. But these bait and switch issues, bringing someone in on a wrong visa and then paying someone to call an immigration court and get them on a final deportation order, which gets them caught in a felony entrapment situation where if they try to leave, they're going to be penalized. If they stay, they're penalized just as harshly. So we're really actually helping the criminals that are going to bring in more people and more abuse and more violence. So that's, thank you.
Yes, thank you both. Questions for our guest? Representative Russell.
Thank you, Mr. Chairman. This is for Mr. Lee. Did I hear you say this is going to be a burden on local law enforcement?
For me.
Yeah.
Yes.
And which law enforcement agencies did you talk with to determine that?
Yes, so this would be a burden on law enforcement because it would create a new system for them to learn and enforce that, frankly, is out of their control. There are several federal regulations that direct immigration judges in when they are supposed to reopen and dismiss these final orders of deportation. And it would require these law enforcement agencies, if they seek to enforce this language, to learn those policies on their own, to have an expert on standby to, inform their decision making.
And who did you talk to from these law enforcement agencies to determine that?
Right. So within most of the police departments and some of the sheriff offices here in Nashville and the surrounding counties, many of the offices have a program where they work with immigrant victims. And for the victims who come forward and are willing to testify, help in investigations, they work with the officers and district attorneys to catch the criminals. The issue with the language of this bill is essentially it would make many of these victims who, under federal immigration law, have a pathway to remove their final order of deportation. It would decentivize them from actually coming forward and talking with local police departments and sheriff's offices.
Did a law enforcement officer tell you it's going to be a burden on them?
No, this is through analysis and experience from working with law enforcement.
Thank you.
Any other questions? Representative Salinas.
Can you explain what a U and a T visa are?
Yes. So what I was referring to earlier was the U visa. This is a program that Congress has enacted, essentially for people who are the victims of very serious crimes, regardless of what their immigration status is. Congress encouraged these individuals to come forward and report the people who committed these crimes and to work with law enforcement to try to catch them. If they comply with the requests of law enforcement, including district attorneys, all the way up to testifying in court, Congress envisioned a pathway for these people, regardless of whether or not they have a final deportation order, to be able to obtain lawful immigration status in the United States. The T visa is a separate program for people who were trafficked into the United States, and similarly, it creates an option for them to, remedy any deficiencies in their immigration history by, reporting this kind of trafficking that we all want to avoid.
And it's my understanding that law enforcement worked with policymakers to make sure that those options were part of it, but these processes are long. Is that correct?
Correct. In order for an individual to qualify for these kinds of visas, they really have to work closely with law enforcement, oftentimes for years before they're able to receive that immigration benefit.
And it's usually the sheriff's department or the police department, depending on the crime that was committed against these people, that signs off on these things, correct?
Correct. Without that certification, the immigrant is not able to proceed with their process.
And in your opinion, would this get in the way of that process?
Exactly. It would make it a lot less likely for people to be willing to come forward because they would face this risk of a Class A misdemeanor.
And do you think that criminals would go free if we enact something like this?
I think many of the people who, have been detained because of brave immigrants coming forward and testifying, those situations would not have occurred because of fear.
Thank you. That's all.
Representative Powell.
Thank you. Question. Currently, obviously, immigration court is civil and not criminal. Is there no minimum age requirement for being placed in removal proceedings?
There's not a minimal age requirement. In my experience, I've sat across the table from 8-year-olds in their pajamas after school and had to break the news to mom that she and all the kids in the room, they all have final orders of deportation.
So then it's possible someone as a child could be face removal orders and then go through life and many years later be charged criminally under this. I just, if you could speak to that, but I think of young Liam and what we all witnessed and how children are being used and weaponized as bait. And that is a ridiculous situation we find ourselves in this country. And I think this bill, if passed, will lead to more issues, specifically those arising in Tennessee. But if you could speak to that and the way this might impact children. Thank you.
Yes, absolutely. So many of the children who receive final deportation orders, they have no idea that they're even in removal proceedings in the first place. They have come to the United States with no input on their own. They're just in class learning their ABCs when over in Memphis, an immigration judge enters removal orders against the whole family. I've certainly met with many teenagers and even adults who, for whatever reason, they never worked with an immigration attorney. They could never afford one. And I was the one to tell them for the first time that they had a final order of deportation.
Leader Lambert.
Thank you, Mr. Chairman. And have you had an opportunity to review the report that the District Attorney General's conference issued a few weeks ago on illegal immigrant crime in the state?
I have not, no.
Well, I know that you mentioned earlier in your testimony that it would be a burden on law enforcement to investigate these crimes. Would it surprise you to know that there were 21,648 crimes committed by illegal immigrants just in 1 year last year in the state of Tennessee?
It would surprise me.
Would it
Yes.
surprise you that 41 of those were homicides?
It would surprise me, yes.
How about 2,183 violent offenses, 1,592 assaults, including domestic assaults, 145 sexual offenses, 11 children that were raped by illegal immigrants, 40 aggravated kidnappings, 2,920 DUIs, and 5,318 cases that were literally just a variety of driving cases. Do those numbers concern you at all?
I would be happy to take a look at the report, but I would also be happy to share some other reports that have found that immigrants in general commit less crimes than non-immigrants.
I'm glad you brought that up. Approximately what percentage of the Tennessee population is illegal immigrants?
That's not a number that I have on the top of my head.
Well, the best numbers we've seen is approximately 2 to 2.5%. That 41 homicides that illegal immigrants committed makes up about 9% of the total homicides committed in Tennessee last year, far beyond any number I've seen of the average number of illegal immigrants in this state. So while, yes, investigating a new A misdemeanor is a responsibility for law enforcement, and we expect them to do it properly and have all the facts before them before they charge someone, these crimes cost far in excess, both in lives and finances, than anything you've described, sir. But I do deeply appreciate your testimony today, and thank you for sharing with us a different perspective.
Any other questions for our guest? Seeing none, thank you both for being with us today. Since we're out of session, we will go to back to Representative Salinas for a question for legal.
So this bill would take something that is in federal, which is immigration court, which is a civil matter, and put it into a criminal and create a state local criminal case, correct?
Fogarty, Office of Legal Services. So under federal law, there is an offense of failure to depart after a final order. It's in 8 U.S.C. Section 1253. This Section 1 essentially mirrors that federal offense.
But it would be bound by state laws, even though it mirrors it, it's under state law.
Section 1 creates a state law offense that is similar to the federal offense.
Okay, so when it comes to appointing of counsel, it would be bound to the same standards as other criminal matters?
Yes, ma'am. Yes.
Okay.
Representative Russell.
Thank you, Mr. Chairman. This is for legal. Legal, is it common practice for state law to mirror federal law?
I don't know that it's common practice. States enact their own laws. I haven't really studied that, so I can't really.
But there is other laws that mirror federal laws, so it can be enforced at a state level. Is that correct?
Yes.
Thank you.
Representative Powell.
Follow up for legal on that. We have pretty clear preemption clause, right? And if the federal government has jurisdiction, it's the state cannot create legislation that would contradict existing law, the federal law. Is that correct?
Under the supremacy clause, federal laws take precedence over state laws. And if there is a conflict, the federal law will prevail.
And any law that this body passed that didn't apply to that could be struck down or overturned, correct?
That would be for a court to decide.
Thank you.
Chairman Farmer.
Thank you, Mr. Chairman. One question. Are you aware of, or do you know if you can get a DUI in federal court?
I don't believe you can.
No, you can.
You cannot.
You can.
Oh, you can. Oh, I
You
didn't
can
know
be
that.
charged with DUI. For example, in between Sevierville or Pigeon Forge and Gatlinburg in the park, you can be
Oh.
pulled over and charged with DUI. And also, you can also be charged in state court here in Tennessee with a DUI as well. So I think that's the best example that I can think of, the most common example of how we have a state law DUI and we also have federal law DUI as well. So just wanted to make that clear. Thanks.
Any other questions for legal? Seeing none, we'll go back into session. Any questions for the sponsor, Representative Atchley? Previous question has been called. There is objection. We will be voting on previous question. All those in favor of previous question say aye. Those opposed? The ayes prevail. We are now voting on the board to send House Bill 1704 as amended onto full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 2 noes.
The ayes prevail. House Bill 1704 is amended, moves on to full judiciary. Item number 2, House Bill 1394 by Representative Pearson will be rolled to the special calendar to be published with the final calendar. We're going to skip down to item number 8. Item number 8, House Bill 1951 by Chairman Williams. You have a motion and a second. You recognize there is an amendment code 13175. Do you wish to proceed with?
Thank you, Chairman, members. I do.
All right. You're recognized on the amendment.
The amendment, this bill has 2 parts, one regarding coercive suicide, the other regarding AI technology. Chair Lady Littleton has an AI legislative package that she's currently working on. So this amendment would simply take out the AI component of the bill so that only the coercive suicide remains. With that, I'd appreciate the members' support removing that language.
Thank you for that explanation. Any questions for the sponsor on the amendment? Seeing none, we're now voting to adopt Amendment Code 13175 on the House Bill 1951. All those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt. We're on your bill as amended.
Thank you, Chairman and members. This bill before you is a revision to the assisted suicide statute, which adds coercive suicide statute to our code, which I worked with the Attorney General's on over the summer because there are always concerns regarding free speech as it relates to matters of communication between members. This bill would create an offense for someone who knowingly encouraged someone to take their own life. Chairman and members, I would appreciate your support, but we do have, this bill emanates from a family in my district who experienced the pain of this themselves, and they've come here to testify today, and with your permission, they'd love to tell about their story before we proceed.
Very well. Without objection, members, we will go out of session to hear from our guest, Candy Sparks, Hannah Duncan. Chairman Williams will help you get set up. You can have a seat at the table and introduce yourself for the record. You'll each have 3 minutes each for comments.
Chairman, Vice Chair, and members of the committee, thank you for the opportunity to speak today. My name is Candy Sparks. I am the mother of Grace Ann Sparks. I am here in support of HB 1951. In 2019, my daughter Grace Ann died as the result of coercion, systematic psychological pressure, manipulation, and exploitation by someone who understood exactly how to push her toward harm while maintaining the appearance that her final act was her choice. It was not, it was engineered. A man who my daughter met via online used his online influence to groom and then eventually convinced my daughter that her choice was to kill herself for his pleasure. He coerced her, he convinced her, and he used his words. Current law struggles to address this reality. When coercion is invisible, when abuse happens through words, isolation, threats, and grooming, rather than physical force, accountability often disappears. Families are left with the impossible task of explaining why something that looks voluntary on paper was in truth the endpoint of sustained abuse. HB 1951 matters because it names what actually happens. It recognizes that suicide can be caused, not by illness alone, not by impulse, but by another person's deliberate actions. This bill gives prosecutors the ability to pursue justice when coercion is a weapon. It also sends a clear message that manipulating someone into self-harm is not protected behavior, not speech, and not beyond the reach of the law. This legislation is not about criminalizing grief or mental illness. It is about accountability for predators who exploit vulnerability and hide behind technical gaps in the statute. It is about deterrence, and it is about truth. If HB 1951 had existed when my daughter was alive, her case would have been understood sooner and prosecuted more clearly. Families like mine would not have had to fight so hard to have coercion recognized for what it is. I urge you to support HB 1951, not only for Grace Ann, but for the many Tennesseans whose suffering is currently invisible under the law. Thank you for your time, and thank you for your service.
Yes, ma'am. Thank you. Ms. Hannah?
Hello. Chairman, Vice Chair, and members of the committee. Thank you for the opportunity to speak today. My name is Hannah Duncan, and I am Grace Ann's sister. I am also the mother of 2 young daughters. I am here today in support of HB 1951 because I have seen firsthand how coercion can hide in plain sight, how devastating the consequences can be when the law has no clear way to recognize it. When my sister died, what happened to her appeared on the surface to be a choice she made on her own, but within our family, we knew there was something deeply wrong. The pressure she was under was psychological, persistent, and deliberate. It did not look like violence, but it was. I wish I had understood sooner how easily coercion can disguise itself as concern or influence. As a sister, I live with the knowledge that coercion does not always announce itself clearly or immediately. As a mother, that knowledge is terrifying. I think about my daughters growing up in a world where manipulation can happen daily and quietly through isolation, emotional pressure, and control rather than physical force, which is much more easily identified. HB 1951 matters because it names this reality. It is narrowly focused and intentional. It does not criminalize mental illness, grief, or difficult conversations. It addresses situations where a person knowingly and deliberately exploits vulnerability after suicidal intent has been expressed with the purpose of causing harm. This bill would not undo our loss, but it would bring clarity where there is currently silence, accountability where there is now a legal gap, and protection for families who may otherwise never know why something so harmful was treated as silence. I urge you to support HB 1951 for Grace Ann and for the families and children who deserve better protection under our law. Thank you for your time.
Thank you both for being with us and for your courage and willingness to testify today. Representative Powell.
Thank you. I just want to say I'm very emotional and moved by your testimony as a parent myself, and I can only imagine. So I'm very sorry for your loss. And I know that there are so many people out there with evil intent who are trying to prey on our children in this state and cause harm. And so I'm grateful that this is moving forward in an effort to try to stop that, and not just children, but also, also this is happening to adults as well. And it's just, we need to do what we can to try to stop this. And I think send a clear message to anybody in this state that wants to harm our children, that they will be punished to the fullest extent of the law. Thank you.
Thank you.
Any other members? Seeing none. Thank you both for being with us today. We will go back into session. Chairman Williams, you recognize, sir.
Ask for approval.
Thank Questions for the sponsor? You have to be recognized, sir. But if there's no questions, Leader Lambert.
Move previous question.
Thank you. All right. Any objection to the question? Seeing none, we're now voting to send House Bill 1951 as amended to full judiciary. Any members wish to change your vote? Don't run off yet. Hold up, hold up, hold up. All right, Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
Thank you. House Bill 1951, the ayes prevailed, moves on. Full judiciary as amended. You've got item number 7, House Bill 2026. Do you want to?
Chairman and members, I do have an amendment, though, that was timely found.
All right.
Drafting code 013099.
Did you say it was timely filed?
I think it is.
Okay, good.
Yes.
Just checking.
Yeah.
Thank you. All right. Need a motion and a second on the amendment. Yes, we got that. All right. You recognize on the amendment.
Thank you. The amendment simply provides an exception for Tennessee Department of Transportation. This bill was originally brought to me by the Tennessee Association of Professional Surveyors. Currently, you can move someone can move property corners that are set by a surveyor without any penalty. This simply makes it a misdemeanor if you knowingly move property corners of a property adjacent to you, or even in a construction project like my company might do. It's incumbent upon you, if you remove those knowingly, to replace them in the appropriate location. So I'm happy to stand for any questions members might have.
All right. I had Representative Powell. You on the amendment or on the bill?
Either, it doesn't matter.
Go ahead.
Okay. Just a clarifying question, and we talked about this beforehand, but if someone was to pull up the wooden stakes that oftentimes get put up with surveys, that wouldn't apply to that. It's just these corner markers, correct?
Chairman, that is correct. This is generally it's a piece of rebar or spike or an iron post or something like that would generally designate that. Much like when you get a new piece of property, surveyor stakes are still there, but those surveyor stakes are really just for someone's view. They're not the actual permanent corner of the property.
Thanks for getting that on the record.
Thank you.
Any other questions on the amendment? Seeing none, we're voting to adopt Amendment Code 13099 on the House Bill 2026. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt, we're on your bill as amended, and Leader Lambert has a question.
Then, Mr. Chairman, just a statement. Thank you for bringing the bill and the last one. I appreciate the testimony. I was viewing it in the back room. But on this particular bill, there's only one reason to move these, and that's if you're trying to steal somebody's property. That's it. I mean, you're trying to move the stakes so that by adverse possession, you can later argue that, well, no, that's really my property. And that's when this happens. And so I cannot believe this was not illegal. Previously, I've already signed onto the bill. I know it sounds relatively innocuous, but look, there are fist fights and attempted murders that have happened over property lines. It is important that we know where the lines are. And so I can't believe this was an oversight in the law for all these years. I appreciate you solving this. Clear property lines and tall fences sometimes make good neighbors. So thank you.
Thank you.
Any other questions for the sponsor? You've already explained the bill when you did the amendment, I guess. All right. Any objection to the question? Seeing none, we're voting now to send House Bill 2026 as amended on the full judiciary. Everyone's voted. Anyone wish to change your vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 2026 as amended moves on to full judiciary.
Thank you, Chairman and members.
Thank you. Let's go to item number 4, which is House Bill 687 by Leader Camper. You are recognized. There is an amendment. There's a couple amendments. Which one do you wish to proceed with?
It is 11373.
11373.
That's the right amendment.
All right,
yes.
you're recognized on the amendment.
Thank you, Mr. Chairman and members. What this amendment does is deal with the 12 months of arrearages being fully paid. We just added that in, that they have to have paid their child support for 12 months, as well as arrearages being current.
Is it my understanding that the amendment makes the bill?
Yes,
Yes, it does.
yes, it does.
All right. Any questions on the amendment? Seeing none, any objection to the question? We're voting to adopt Amendment Code 11373 on the House Bill 687. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt. We are on your bill as amended.
Thank you, Mr. Chairman and members. I did want to make clear that this amendment does not alter the voting rights restoration process that was created by Halsey's bill last year, but we were willing to work with him and put this one off until he did the comprehensive things he did last year, that this just removed it put it in the restoration court process. This does not affect it. So you've read the amendment. It makes the bill. It makes sure that, and you all know this, it removes that the unpaid fees and fines are not a condition for restoring your rights to vote, and they will be current in their arrearages, and they will have paid it, their child support, and they will have paid it current for 12 months.
It's my understanding restitution will be, you will have to be
You
current
all
and
your
full
restitution, all of it.
restitution.
All of that remains the same.
Okay.
Nothing has changed on that.
We do have someone here to testify on this bill. So we will go out of session. Hear from Joanna Cohane. Hopefully I said that right. Thank you. You're no stranger to this committee, so introduce yourself for the record and you'll have 3 minutes for comments.
Thank you, Chairman. My name is Johanna Cohane. I'm from Robertson County, and I signed up to speak on this bill because I hold 2 fundamental beliefs that this bill speaks to. The first is that everyone who can legally vote should vote. And the second is that for those who've committed a crime, been adjudicated, served their time, and been returned to society, one of the biggest factors in overcoming the risk of recidivism is a connection and support from community and a hope for the future. I believe this bill provides that. The action of voting is a very important way a citizen can participate in the future and direction of local areas, the state, and the federal government. I've heard of the organization Men of Valor, honored at the State House, and seen presentations on the good work they've done to lower recidivism in Tennessee. They do that by offering the individual community and support. They provide safe housing, they provide job training, they provide aid with transportation, they provide education opportunities, but they can only help so many. For those who participate in their 12-month aftercare program, the recidivism rate is less than 15%. I mention them only to say what community and a hope for a future can do for people that have been convicted of a crime. By removing the permanent ban on voting, the individual released from prison has the hope of more fully participating in society. They'll have a better connection and hope for the future. As someone who holds voting as very important, I've been at voter registration drives and spoken with people who cannot vote because of a past felony conviction. I believe that when a crime has been committed, then it should be righted, but I also believe the punishment needs to fit the crime. And that once that time is served and the person is released back into society, they should be allowed to vote. Right now, the system to restore voting rights is complicated and costly, Instead of being supportive and offering a way back into society, the individual is met with obstacle after obstacle. This bill will change that and give them hope of participation in society. And I appreciate this bill and the impact it can make on the lives of Tennesseans. Thank you.
Thank you very much. Any questions for our guests? Seeing none, thank you for being with us today. We'll go back into session. Leader Camper, any closing statements?
Thank you, Mr. Chairman. I just want to thank everybody for working with us over the last year with this bill. Appreciate all the input everybody has given to us to make it a comprehensive and better bill for our constituents. And appreciate a favorable vote.
Any questions for the sponsor? Seeing none, objection to the question. Seeing none, we're now voting to send House Bill 687 as amended to full judiciary. Everyone's voted. Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 687 as amended moves on to full judiciary.
Thank you, Mr. Chairman and committee members.
Thank you. All right, let's go to item number 5, House Bill 1933 by the notorious Chairman Vaughn. You are recognized. There are no amendments.
No, sir. I'm here today at the request of the Shelby County District Attorney. What we're asking for is a TASER study to report for a pay equity on ADAs across the state. And I know that in the Shelby County DA's office, they have some that have been employed by the county, some employed by the state. They're doing functionally the same job, but the pay rates are different. And so what this has brought about, when I was told that, I thought it was a curious situation, and I wondered where else it occurred across the state, because I'd like to look at it from a statewide perspective. And so I agreed to request this TASER study so that we could get some information to present for our consideration, and also to give those people on the ground in the various ADA's offices the ability to understand what's happening from a larger peer group as well.
Thank you for that explanation. Leader Lamberth.
Move previous question.
Previous question called. Any objection? Seeing none, we're now voting to send House Bill 1933 to full judiciary. Does anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
Ayes prevail. House Bill 1933 moves on to full judiciary.
Thank you for your consideration, Mr. Chairman. And just on a fun fact note basis, you referred to me as notorious. My grandfather's name is Biggie.
I'm sure he was a tall fella. All right, item number 6, House Bill 2065 by Chairman Todd. You are recognized. There are no amendments.
That's correct, sir.
Please proceed.
Thank you. This bill adds disrupting religious assemblies to the offense of aggravated criminal trespass. I'll be glad to take any questions.
Thank you for that brief explanation. Representative Powell.
So I know that existing law already covers assault, vandalism, disorderly conduct, disruption of meetings, and existing aggravated trespass. So can you clarify what specific conduct is not already covered by the law?
Thank you, Mr. Chairman. This bill, recent events have highlighted that we have some gaps in our state's criminal trespass and public assembly laws, particularly regarding places of worship. It directly addresses that type of conduct by expanding the aggravated criminal trespass statute to explicitly prohibit entering a house of worship without consent and disrupting a religious service, making such disruptions a Class A misdemeanor.
Thank you for that response. And I know that it protects religious assemblies specifically, but it doesn't apply equally to other assemblies such as like a school board meeting, community forums, political meetings. Can you say, I know recent events, can you speak to specifics of what you're describing when this has happened?
Yes, sir. The recent events I referred to were in Minneapolis, St. Paul, where protesters entered city's church during a worship service and disrupted the congregation's ability to freely worship.
Okay, so that's what I thought. Under the bill, what qualifies as a disruption? How is it defined? And how can you make sure that a peaceful protest is not unintentionally criminalized?
Thank you, Mr. Chair. Thank you for that question. A person commits aggravated criminal trespass if they knowingly enter or remain on property without the owner's consent and they engage in certain harmful conduct. It clarifies that this includes situations where the person intends, knows, or is reckless about causing fear for others' safety, damages or removes barriers such as gates, locks, fences, or signage to gain entry, or recklessly damages property on the premises. And it involves disrupting a religious assembly inside a structure on a property. So we were very careful to not include any religious assembly, because if that was outside in a public space, then folks have the ability to freely assemble. And even a protester could do that in an outside venue. So we made sure this was inside a structure.
Follow-up question, is this aimed at violent conduct or expressive activity? And if it is violent conduct, why are the existing statutes insufficient?
Again, I reiterate, it involves where they intentionally, knowingly, or recklessly cause fear for other safety. So that's a big factor. They do some damage and remove barriers to gain entry, or they recklessly damage property on the premises in that process. So I don't know if that specifically answers your question or not, but that's what it does.
And just in closing, I guess, and I appreciate your responses. I certainly support protecting people from violence wherever they gather and whatever that means that is. But we already have statutes addressing assault, vandalism, disorderly conduct, trespass. And I'm concerned the bill singles out one type of assembly and risks constitutional overbreadth issues. We should enforce our existing laws before creating new ones that I believe won't withstand scrutiny, judicial scrutiny. So I'm glad you pointed out this is targeted at those people gathering and trying to go after the people that are protesting in Minneapolis. But I think this unnecessary bill, and it has major constitutional issues. Thank you.
Obviously, I'm not targeting anybody in Minneapolis. That's not what our laws do. So this is specifically for Tennessee. It's for Tennesseans. It's for our citizens that gather to worship. They should be able to do so freely and without fear of somebody barging in and disrupting their service without welcome.
Thank you for that. Leader Lamberth.
Thank you, Mr. Chairman. So there's no such thing as a peaceful protest when you're on someone else's private property and you've been asked to leave. It is their property, be it a church, be it a home, be it a business. You can peacefully protest on public property, and the First Amendment supports that and protects that. You cannot go on someone else's private property and do so. And the First Amendment also protects our right to assemble and worship as we please. And the reason I don't think a bill of this nature has ever been put forward before, because I don't think anyone had ever dreamed that organized protesters would try to make a point, and do it very poorly, I might add, by busting up into a church service where people are trying to exercise their First Amendment rights and somehow or another insist that their right to protest extended to private property. It just doesn't. If they want to go into a church and worship with those folks and experience the love that is there and enjoy the First Amendment rights that those folks have to be able to worship, then come on. Come into any church you want to, you'll be welcome. But if you come in and try to disrupt and make it all about you instead of the worship that is going on there that is much larger than an individual's effort to just make it about them, then this bill goes from a B misdemeanor to an A misdemeanor. Yes, that's a big deal. A B misdemeanor is basically a traffic ticket. An A misdemeanor, you could serve up to 11 months and 29 days in jail. You cannot peacefully protest by breaking into or remaining on someone else's private property. It's nonsensical. And with all due respect to my colleague, I wish we wouldn't insinuate that folks should do that, because there are plenty of places to peacefully protest. You don't have to infringe on someone else's rights to do so. And it is disappointing we live in a day and age where the sanctuary is no longer a place of worship for some folks. It's seen as a place to disrupt and make it all about an individual instead of about God, which is what that worship service was about and is when we gather for any religious service. And folks don't have to gather for religious service. They can either worship or not, protest or not, but you can't go into private property and do it. Thank you for the bill. I think it's extremely helpful.
Thank you for that, Representative Salinas.
Thank you. I share the concerns that constitutional concerns as well. Does this apply to all places of worship like mosques and temples?
Thank you, Mr. Chair. Yes, it does.
Okay, and what about areas where two things can be combined? For example, many of our schools that receive vouchers are religious schools, where you have places of worship within the school. How would your bill address those areas, and are those areas also protected by this law?
Thank you, Mr. Chairman. I believe disrupting religious assemblies would apply across the board. That's the wording. So I believe it would apply where in those instances you're describing.
Okay, so if the Muslim school in my district is having prayer and they have prayer 5 times a day, but only like 2 to 3 prayers, and someone disrupts that prayer, your law would make that a misdemeanor.
Thank you, Mr. Chair. I believe it would.
Okay, because the reason why I ask this is because Moms for Liberty has done that and has targeted Muslim schools and other religious institutions. So according to you, they would be protected by your law. That school would.
Thank you, Mr. Chair. If it meets all the criteria that's outlined in this bill, yes.
Okay.
Chairman Farmer.
Thank you, Mr. Chair. Move to previous question.
Previous question is called. Any objection? Seeing none, we're now voting to send House Bill 2065 on the full judiciary. Everyone's voted. Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 2 noes.
The ayes prevail. House Bill 2065 moves on to full judiciary. Item number 9, House Bill 1731. By Representative Wright, you have an amendment code 13089. Do you wish to proceed with that amendment?
Thank you, Mr. Chairman. Please place the amendment on the bill.
All right, you recognized on the amendment. The amendment make the bill?
No.
Okay. You want to explain? The
I will
amendment?
explain the amendment.
Okay, thank you.
The
Okay.
amendment adds a third category of persons that may remove something from a cemetery site. The bill is presented, talks of the family or employees of the cemetery. The added term refers to an employee of the Department of Environment and Conservation Division's archaeology, removing something from a burial site.
Great explanation. Thank you for that. Any questions on the amendment? Seeing none, objection to the question. Seeing none, we're voting to attach amendment code 13089 on the House Bill 1731. All in favor say aye. Aye. Those opposed, the ayes prevail. You adopt or own your bill as amended. Any questions for the sponsor on this bill? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1731 as amended to full judiciary. Has every member voted? Any member wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 1731 moves on to full judiciary as amended.
Thank you, Mr. Chairman and committee.
Don't go away. Item number 10, House Bill 1748 by Representative Wright. You are recognized. No amendments. Please proceed.
No amendments. Thank you, Mr. Chairman, committee. This bill, House Bill 1748, was brought to me by the Tennessee State Court Clerks Association, Mike Hammond, President, and the County Officials Association of Tennessee. They have worked with the association has worked with the Tennessee Department of Treasurer, and this bill concerns the law related to indigency determinations for the Electronic Monitoring Indigency Fund. It revolves around being determined indigent, and it's related to SNAP, TANF, or TennCare. The court clerks will collect the information regarding the defendant's status. They'll provide it to the electronic monitoring device provider, and the provider will relay that information to the treasurer's office. The bill does not change eligibility standards, does not expand the program. It's just simply a clarification of a bill we passed last year and who does what. The Tennessee State Court Clerks Association appreciates the Treasurer's Office for working with them on this bill. And with that explanation, although not brief, I stand for questions.
Any questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 1748 on to full judiciary. Does anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 1748 moves on to full judiciary.
Thank you, Mr. Chairman and committee.
Representative Wright, I got a quick question for you.
I've got a quick answer.
I noticed that bright orange coat. Are you a Syracuse fan by chance?
I'm a serious Go Big Orange fan. And if I were to have missed my spot today here, I would have had the Vice Chancellor, the UT campus in Knoxville, Dr. Keith Carver, here to sign my excuse statement. So I want you to know I'm Big Orange.
Very good. Thank you.
Thank you ever so much.
Thank you for your time. Goodbye. You're dismissed. All right. Item number 11, House Bill 1449 by Representative Gillespie will be rolled 1 week. Item number 12, House Bill 1624 by Representative Barrett will be off notice. Item 13, House Bill 850, Representative Renaud will be rolled to the Hill. And I hope that item number 14 sponsor is ready to rock and roll. She's ready. All right. Item 14, House Bill 1765 by the Chair Lady Littleton. You are recognized. There is Amendment Code 12700. Do you wish to proceed with that?
Yes, Mr. Chairman, I do.
Seconded on the amendment. Please explain the amendment.
This bill, as amended, enhances from a Class A misdemeanor to a Class C felony the penalty of knowingly violating a lifetime order of protection when the conviction on which the lifetime order of protection was due to an offense involving the use of force against a victim.
Any questions for the sponsor on the amendment?
And the amendment does make the bills.
Okay, well, very good. Thank you. Amendment makes the bill. Any questions on the amendment? Seeing none. Objection to the question, seeing none. We're now voting to adopt Amendment Code 12700 on to House Bill 1765. Those in favor say aye. Aye. Those opposed, ayes prevail. You adopt. We're on 1765 as amended. Any questions for the sponsor? Leader Lambert.
Thank you, Mr. Chairman. Again, just thank you for bringing the bill. I mean, this is, we continue to improve these lifetime order protections every year. And just as a reminder, I mean, before we as a legislature several years ago started going down this path, and it was Nikki Gosher that actually brought these up. I mean, her husband had been killed right in front of her, and there was this horrible murderer that killed her husband in prison was still sending letters out to her. And she would have to go down every single year and get another order of protection. And so this allowed for a lifetime order of protection. And I don't know any other states out there that are doing it. I know some have started trying to do that now. But it's just another example of Tennessee leading the country on this, and specifically of Chairman Littleton continuing to lead for the time she has left in the legislature. We're going to miss you, that's for sure, on trying to make sure that we keep specifically victims of domestic and sexual assault safer in this state and to support them in every way. So it's a very important update, and I just want to thank you for bringing it, Chairman.
I renew my motion.
Okay. Any other questions for the sponsor? Seeing none, objection to the question. Seeing none, we're going to vote now to send House Bill 1765 as amended to full judiciary. Does anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
Thank you for that. The ayes prevail. House Bill 1765 as amended moves on to full judiciary. Item 15, House Bill 1812 by Chairman Russell is going to be off notice. Item 16, House Bill 1542 by Representative Atchley. Are you ready to roll?
Motion. Item 16.
Yes, sir. All right, you're recognized. There is no amendment, so please proceed.
Thank you, Mr. Chairman. A person commits telecommunication fraud when the person with intent to deprive the owner of property uses a telecommunication device to fraudulently obtain or exercise control over the property of another without the owner's effective consent. Telecommunication fraud is punishable as theft pursuant to 3914-105, but in no event shall telecommunication fraud be less than a Class C felony. This is just simply moving it from a Class A misdemeanor to a Class C felony.
Any questions for the sponsor, Representative Powell?
Thank you for this sponsor, if you could. So could you give me an example of how somebody might use this?
Yeah, it's really a scamming bill. There's so many people being scammed. These people are sitting in other countries and calling people, and they're scamming them out of their money. And I've witnessed this so much this summer and was personally affected by a family member. And I never, in my time in law enforcement, I never really dealt with this and didn't realize how bad it was until this summer. And this is somebody we all know, family members that's been affected with this. And when you use your telephone or whatever electronic device to call somebody and steal their money, that's just wrong. And I'm asking to change it from a misdemeanor to a felony.
Thank you for that. And I certainly have heard this problem and aware of this. It's really sad right now, based on just recently with the disaster, the ice storm disaster that hit a lot of the state, particularly Middle Tennessee. Now you've got people out there trying to fraudulently do some of these things to get people's property who have been hit really hard and are vulnerable. And so I understand the problem, and I appreciate the explanation. Thank you.
Thank you.
I've got a question for you, sponsor. This is, you're criminalizing the act of using a telephone to do this, not necessarily of placing the call. So if I was to call you and try to coerce you into giving me money, making under false pretenses to steal that money from you, that would be applicable here. If you were to call me because of an ad you had seen somewhere, and then I tried to steal money from you, I think that would be applicable here as well, because we're using the phone. Is that the way I understand it? Or is it limited to the actual call itself, or is it
No, it's just
the two-way communication?
Yes.
Okay. Thank you. Any other questions for our sponsor? Seeing none. Any objections to the question? We're now voting to send House Bill 1542 on to full judiciary. Everyone has voted. Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 1542 moves on to full judiciary. Item 16, or 17 rather, House Bill 1644 by Representative Ashley. You are recognized on your bill there. You want to discuss it? Or what you?
We've taken that off notice.
All right,
for
well,
a
it's off
little bit,
notice then,
so-
if that's what you want.
Yes, sir. We'll be ready in about a week or so.
Okay, so without objection, we'll take House Bill 1644 off notice. I'm going to jump back to item number 3. It's got my name on it, so I'm going to pass the gavel down.
Motion. All right, members, we're on item 3, House Bill 369 by Chairman Doggett, and I believe you have a motion and a second, sir, and I'm looking at House Amendment 12764. Is that something you'd like to move forward with?
That is correct, and
Second.
yes, thank
All
you.
right, very good. And you got a motion and a second. You want to discuss that now, or you want to clean up the bill and talk about it all?
I will. I believe the amendment actually just changes the effective date.
Very good. Members, any questions about that? All right, seeing none. All those in favor of adopting House Amendment 12764 to House Bill 369, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're properly recognized.
Thank you very much. Members, this bill deals with changing grades for the purposes of a credit recovery program that you'll see in your high schools. It allows an instructor of that program to go in to make those necessary changes to the students' grades and not be potentially criminalized under current statute. So we're just making a change there to make that process legal as it should be.
Very good. Members, any questions for Chairman Doggett? Going once, going twice. Question's been called. Any objection to the question? Seeing none. All right, members, we're going to be voting to send House Bill 369 as amended to full judiciary. So all those in favor, vote aye. Opposed, vote no. Has everybody voted? Anybody like to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
Very good. House Bill 369 as amended moves to full judiciary.
Thank you. Thank you, members. That brings us to the heel of our calendar for House Bill 850 by Representative Renaud. She is not in the room, so we are going to take a 2-minute recess without objection. All right, members, we are going to go back into session. We were on House Bill 13, or Item 13, House Bill 850 by Representative Renault. She is not in the room. Without objection, this will be rolled to the special calendar to be taken up with the final calendar. Any other orders before we adjourn for the day? Members, I appreciate your hard work. We moved through an entire calendar today. Let's keep up the good work going forward. We are adjourned.